Mr. Bergmann.
Thank you, Your Honor. May it please the court, Ms. Link. Mr. Hernandez is here today to seek a remedy from you. It said that there should be no wrong under the law without redress. In this case, he sufficiently pleaded a claim of ineffective assistance of counsel. It was dismissed. So you all look at this case as though the pleadings are true, and you construe them in the light most favorable to him. He complied with the Iowa Constitution, Article 1, Section 13, and with Iowa Code, Section 663. Well, the Constitution says he has to do it legally. The Code, which is the same as it was when the state was incepted and when the Constitution was ratified here in the state, says that he must state that he is restrained in his liberty and state who and the place where it's so restrained. He specifically did so. He said he's restrained in his liberty due to a conviction, or a quasi-conviction as it were, based on ineffective assistance of counsel.
Counsel, isn't it important, though, that we get to the question of who's restraining him? And the challenge I see for you is that he's not being restrained by the state. If he's being restrained by anybody, it's the federal government. You're asking relief from us, from the state. Mm-hmm. So how do you get over that gap?
All the restraint is flowing from this conviction or quasi-conviction. I'm just going to say conviction just to save time. It all flows from that. And this is not an issue that the state argues or the Court of Appeals argues it would be decided by the Supremacy Clause issue, which is the Tarbell case. It's not an issue where you all are ordering the government to produce someone, because this is a restraint statute here in Iowa. It's a custody statute under 2254 and 2255. All the restraint flows from Iowa. This is an Iowa conviction decided by an Iowa judge.
We've held these post-conviction relief actions are moot once someone has served their sentence, when they're released from prison. And then that's clearly the law in Iowa. Why isn't it the same apply when someone's released and not on probation anymore and not under the jurisdiction of the court?
Well, that has not been the law under the federal Constitution or the federal habeas statute since 1968. So if that is the state of the law in Iowa.
Reiner, we said that once you're released from your prison sentence, your post-conviction relief action's moot. And we've said that.
Right. But that's not the case under the post-conviction relief statute. And when the legislature adopted the post-conviction relief statute, they did so under the ABA model rules, which has a long, or model proposal or whatever, which has a long discussion about why that's the wrong thing to do. Because there's tons of litigation about it.
We did it in 2005, so do we need to overturn that case and basically say now it's not moot anymore? Because the issue in that case, we cited 4 or 5 cases where it was moot, and then we said, again, with this morning's argument, is it great public importance and tends to reoccur, and I don't remember what we did in that case, but we have that ruling, and I don't know how I think you got to go over that hurdle before we can even get to your question.
On mootness.
Yeah.
Well, the U.S.
And if it's moot, what relief do you get if we can't do anything?
Right. Well, the federal court has decided that if you want to be persuaded by them on this Iowa habeas, is that it's not moot when someone gets out of custody. The case is Carafas v. Lavalle out of 1968, where they said under the federal habeas statute, you have to file it when you're in custody. But just because your case lasts beyond your statute doesn't mean that it's moot anymore. They said, in the consequence of his conviction, he can't engage in certain businesses, he can't serve as an official in a labor union, he can't vote in an election in the state of New York, he can't serve as a juror. So they said it's not moot.
Well, I think you've got an interesting point, and that is that you bring a habeas claim and not a PCR claim. So you're not hung up with some of the language in the PCR statute. Nonetheless, I'm going back to the question. It is true that, I take it, that your client's in federal custody. Had he been in state custody, that might be raise a different set of issues. but how do you deal with that issue?
Because the restraint is caused by the state conviction.
State isn't holding him, obviously.
But the word isn't custody. The word in the statute is restraint. And the legislature could have used custody. In fact, they know what that word means. They knew it back whenever they adopted the Constitution. We did a search on the PDF. They used it 84 times. They didn't use custody. They used restraint. The Tennessee Supreme Court in May v. Carlton, 245 Southwest 3rd, 340, said that restraint of liberty is a broader term and encompasses situations beyond actual physical custody. A petitioner is not restrained of liberty unless the challenge judgment itself imposes a restraint on his freedom of action or movement. And they also went on to say, this is the court, and this is actually the Tennessee Supreme Court citing to the U.S. Supreme Court, determined the great writ could be invoked, allowing a petitioner to test the legality of a judgment and frame the appropriate question to be whether the conditions, quote, significantly restrain petitioner's liberty to do things which in this country free men are entitled to do. And in this case, Mr. Hernandez is essentially going to get deported because of this. He's going to be away from his wife and his 4 daughters. He's not going to be eligible for cancellation of removal, which would get him to stay here, which would get him a green card, because he's not eligible for the petty offense exception.
What, the state of Iowa, the state of Iowa, by doing a deferred judgment, hasn't restrained it. You know, he did his probation, so the judgment disappeared, right?
No,
Or am I wrong in that? Tell me.
because the conviction is what's causing all the problems. What I intend to do, and his immigration counsel intends to do, is if we can get this conviction overturned, and it is a conviction for immigration. It's a conviction. It doesn't matter if you all call it a deferred judgment or not. It's a conviction. It has the same effect as a conviction. So it all flows from that. And when the judge accepted his guilty plea that was resulting from ineffective assistance of counsel, and he did do a guilty plea, and then it's deferred, right? That's where it all flows from. If this can be overturned, all those paths that are blocked to him now will open. It all flows from the state conviction. He is restrained by the state conviction. The restraint comes from the state. Subtract that, he doesn't have the restraint anymore.
Well, let me just, I'm going to go down a slightly different path because I think factually this case is pretty messed up, and I just don't see any kind of rational basis for the exercise of this, and I'll just tell you that up front. Number one, because factually, when he does the guilty plea, in bold face, he says and he checks, he knows that there are immigration consequences of this, including deportation. Serious, bold. He knows that at the time. Then in your petition, you say that he's already subject to a detainer at the time of his guilty plea. But we don't have anything in the record that shows that he's subject to any deportation order or any detention order. There's nothing in the record that says that. Mm-hmm. Then I still have an objection with the fact, or the claim in the petition, that he's not subject to the petty criminal definitions, because to me, my reading of that statute clearly says that he is. And so explain to me how he isn't.
He is not, because he is sentenced to more than 1 year in confinement.
Under the deferred judgment, that's not a sentence. He was not sentenced to any period of incarceration. He was put on probation for 1 year. That's not a sentence, and our case law says that clearly. It's not a sentence. The statute itself says that it's not a sentence, and so how can that be?
I love that argument. That's what I would say too if I were the king of the Board of Immigration Appeals, but I'm not, and they disagree with us. They don't care. It's what's imposed. If he would have gotten an imposed sentence of 179 days, but they count it as a sentence. This is the catch-22 he's in when he gets a deferred judgment, because under the Iowa Code, if he gets a deferred judgment, he can't qualify for the petty offense exception. And I agree with you, but that's not how the Board of Immigration Appeals reviews it or how they construe it.
Well, was he subject to a detainer at the time of his guilty plea?
Once he admits the facts, he is. because the only result that can come from that is a sentence, which the Board of Immigration Appeals construes to be more than 6 months.
So in other words, you're telling me, and again, there's nothing in the briefs or anything that says this other than the bold assertion he doesn't apply to this, but I have no authority in any of the briefs or anything that says that he's not subject to the petty criminal offense exception.
I don't have the site for you right now, but I could certainly get it for you.
Now, following up on Justice Zager's other question, I haven't read Padilla recently, but it's your position that this disclosure doesn't fulfill the attorney's duty under Padilla.
No way.
There needs to be more specific advice about the immigration consequences.
Way more specific. Way more specific. And it should include an advisal about the petty offense exception. If a criminal defense attorney is going to take on one of these cases, and I might be preaching from the pulpit here, they ought to know the petty offense exception. They ought to know how to get the petty offense exception. And they ought to know that a deferred judgment doesn't do him a lick of good. Not at all. None. There's no reason for him to take a deferred judgment unless he's on a theft case where he could get more than 1 year. Then he could get a deferred judgment, and that would help him because under aggravated felonies, that makes a difference, how much time he actually does. On CIMTs, crimes involving moral turpitude, it doesn't. It's how much time he's given, suspended or not. What's hanging over his head, as we say. And in a deferred judgment, the BIA says it's a year hanging over his head. And I notice you shaking your head, and it doesn't make sense to me either, but I promise you that that's how it is, and I can get you the case if you all want.
Well, I think it might be enlightening because otherwise he clearly falls under the exception. We don't consider that to be a sentence. He wasn't sentenced to any period of incarceration. The statute talks about being sentenced imprisonment in excess of 6 months, which he wasn't imprisoned for in excess of 6 months. Yes, I'm talking, and no, we don't have.
Well,
That. You know, that's what I read the statute, I'm telling you what the statute says, and you're saying, well, interpret it effective.
I'd love to give it to you if you would like me to get that to you.
Oh, you're saying as a matter of federal law, whether or not something's a conviction, conviction's, as we know, a spongy term, and some jurisdictions regard a conviction as including deferred, some don't, et cetera. But what I gather your argument is that the federal immigration authorities regard a deferred judgment as a, quote, sentence.
Exactly.
Take that one further, you're saying that counsel was ineffective for failing to know the consequences that a deferred judgment would have had him deported, and that's why I think it's incumbent upon you to file a notice of additional authority that was the law at the time this guilty plea was taken.
On how the BIA construes petty offense exception.
At the time this guilty plea was taken. I mean, if it wasn't the federal law at the time the guilty plea was taken, or the counsel advised him to do it, then how can it be ineffective? I mean,
Sure.
Does he have some further federal avenues of appeal if the BIA is misinterpreting the petty offense rule?
He could go to the 8th Circuit, but I'm fairly confident that that's how the 8th Circuit is construing it as well. As to the suggestion that he could go to federal court for a habeas claim, he can't. The statute of limitations is passed. This federal statute uses custody. It doesn't use restraint, and he's not in, per se, custody and of the federal government, and he has to show exhaustion. So those aren't available to him. I've got 40 seconds left. I know I've got rebuttal, but I want to just note the juxtaposition between the case before me that happened before me, where there were constitutional rights regarding property, farmland perhaps, I don't know. And here we have really the most essential, or really important anyway, whether or not someone can be here with their family. Can they be in the United States? Have they suffered ineffective assistance of counsel in a criminal case? And Like Ralph, which is a case that's really important to you all, I know, and to me as an Iowan. Mr. Hernandez seeks a writ of habeas corpus under Iowa law. Ralph was in the custody of a bounty hunter, and this court granted a writ of habeas corpus to stop that. In this case, Mr. Hernandez has, frankly, a better connection under the Constitution and the statute. All his restraint flows from that conviction. He's got a better case than Ralph does. He's got a better case than Ralph. And without this, based on the Dombaugh case, he's got no other recourse. I encourage you all to consider, though it's not, you're not in the business of making statements, does Mr. Hernandez have no recourse in Iowa? Thank you, Your Honor.
Thank you, Mr. Bergmann. Ms. Link.
Morning, Your Honors, Mr. Bergmann. May it please the Court. The Court of Appeals and the District Court here both properly found that Mr. Hernandez's petition needed to be dismissed as a matter of law, where he's asking an Iowa court to discharge him from custody to grant release from a federal custodian, which is simply a remedy that Iowa's courts cannot grant. They cannot do so under binding U.S. Supreme Court precedent rooted in the Supremacy Clause. Because that is not a position that we're asking this court to adopt, or a position that this court, frankly, can reconsider, that really ends the matter here. Habeas action cannot be granted against a federal custodian, be that the Department of Homeland Security.
It strikes me that that's kind of, and you know, I read Judge Tabor's opinion carefully, but it strikes me that's kind of an abstract concept here, because what we're not actually going to tell the federal government to do anything, which we would certainly have questionable power to do that. But if we granted the relief that Mr. Bergmann requests, we would simply be vacating the deferred judgment that our courts granted, a lower court in our state granted, and send that case back for further proceedings.
I would have to disagree with that, Your Honors, in part because the nature of the remedy is defined by the vehicle which we search. The post-conviction relief statute obviously provides for essentially going back through errors in a plea proceeding or a trial and overturning the conviction. Habeas is not about that. Habeas is purely about restraint, and even our case law in this state on habeas.
But now you're in a different argument. Now we're talking about the interpretation of the statute, right? We're not talking about the earlier argument, and the one that I think the Court of Appeals focused on was, you know, can we force the federal government? We have no power in the federal government. Now we're talking about why under the statute, under 663, can't we do that?
Certainly, Your Honor. First of all, I know of no law in Iowa when the habeas statute was the primary post-conviction relief method to suggest that we somehow treat the great writ differently than the federal government. In fact, we routinely looked to federal government to interpret it. Specifically also in the statute, if you actually read all of the provisions, we have a form, like a draft writ with fill in the blanks, and it's very clear that the defendant in a habeas action is the custodian with physical restraint. The writ says you must produce the body to this court, and further, that if the relief granted, which is freedom from the illegal restraint, which is understood as physical custody, cannot be granted, then that is a jurisdictional issue.
Could he have brought this action while he was still under probation? Because there is a restraint there?
I think it is possible. I think that obviously our habeas case law stopped a while ago. The federal habeas case law does recognize probation as being custody, so that is certainly, I think, possible. That's never been made here in the state, so we would need to.
Give you another example. Let's say we had somebody who went through a trial, was convicted in the Iowa courts, and for some reason or another, he's sent to Leavenworth or Yankton or some federal prison, maybe because there's some concern about his safety or something like that. And then, can he file a habeas in our or a post-conviction relief? It wouldn't be a habeas, a post-conviction relief proceeding in our courts, even though he's in custody from technically by federal officials as opposed to state officials?
Your Honor, I do not have a specific case site on this. I'm looking back to Fed courts, which is a couple years ago. I do seem to recall that there is a case slightly similar that suggested that where, for example, I think it was something like Alabama was holding someone but under a formal detainer by Kentucky, that the courts would consider Kentucky to be the custodian and thus would have grounds to issue the writ. So I think so. Of course, I do not have precedent that I can cite.
Going back to my example, though, the person, I think you agree that if the probation was still going on, this action might have some legs if they can prove some of the other things. Why should it get cut off when probation ends, when the conviction still provides a restraint on this person's liberty? And that's the argument he's making, but tell me what the difference is technically when you're under probation and now you're free from probation, but there's still that restraint there. Tell me what the difference is.
Your Honor, I think, first of all, I have to respectfully disagree that restraint is simply looking to a cause of some downstream collateral consequence. I certainly know of no case law to suggest that that is how we use a habeas action. So I don't think that that is an appropriate manner in which to
Oh, but it goes
interpret
to the heart. Functionally, although he is in federal custody, and he is in federal custody under immigration law, I take it, but the root basis of his immigration consequences is his state conviction and sentence under immigration law. Is that not so?
I don't fully agree with that, Your Honor. I think that, number one, under the habeas case law I've seen, we don't consider someone automatically suffering from collateral consequences of doing so because of a conviction. Obviously, there's not a conviction here. However, I think in the immigration context in particular, it's pretty noteworthy that, I mean, if you look at the purpose, design, and actual text of all of the statutes and agency regulations, he is suffering an injury based on federal law. Federal law in the statute, and I think Mr. Bergmann alluded to this somewhat when we were discussing petty offense exceptions and aggravated misdemeanors, does not look to Iowa law to tell it whether somebody has in fact committed an aggravated.
Oh, I understand that. I mean, in fact, the federal government has its own regime for what's conviction and what's the sentence and so forth and so on. But they're looking to what happened in the state procedure to say, well, was this a, quote, conviction under federal law? Was this, quote, a sentence under federal law? So I guess my point is a more narrow one. Causally, his restraint is a result of what was in Iowa, his deferred judgment. Is that not so?
I think we actually don't know on the record because we don't know what he has been informed of or what that says. I have no idea if there are other grounds for him being held there or what the letter says. Again, I think the Court of Appeals mentioned that it was listed as an exhibit, but we have never seen that, which is also why I object to the suggestion that Mr. Hernandez has actually established that he is in custody anywhere. There's nothing in this record to indicate where he is. He could be at home. He could be in prison on another charge in another state. He could be vacationing somewhere else. So I do not think that we can suggest that because the defendant decided to take advantage of a statutory privilege that we have found in this state to waive appeal because you were getting the benefit of not having a conviction, of not having a judgment here, does not automatically lead to his deportation. Moreover, being deportable does not also indicate that you will in fact be deported. And it leads me to a greater concern that I have with some of the perhaps tenor of this litigation is this idea that I don't have a remedy. I think saying I do not have a remedy is a far cry from saying I do not have the specific remedy I want in the specific court I want at the specific time I want, which is really what this case is about. As we discussed earlier, I think even if he could not have brought a state habeas claim when he was in probation, I think he could have brought a federal habeas action under 2241, which is also available in addition to 2254 and is not based on conviction at all. Excuse me. In addition, it was his decision when he elected a deferred judgment with the warning that it would expose him to immigration consequences. To waive those rights to appeal, he further selected to proceed to sentencing. Otherwise, he would have had the ability to file a motion in arrest of judgment. And moreover, he has an entire adjudicative process through the immigration.
And I understand your equitable argument. Sometimes your argument is basically he had a remedy, but it was before and not now, and that's not uncommon in the criminal law. But I want to focus on the wording of 663. Which of the elements has he not met? One element his liberty has to be restrained. One could argue that it's restrained, couldn't one? I mean, there's certain things he can't do. He can't leave the United States. He wouldn't get back in.
I am not aware of any law to support that as restraint.
Okay, so that would be one element that's missing, and the other is the restraint is illegal. That's basically the other, and his argument is it's illegal because it's based on a conviction that was obtained in violation of the United States Constitution because he received ineffective assistance of counsel.
Your Honor, I would just push back on that. The specific elements also require him to describe the person who is restraining him and the place of restraint, neither of which are described in there, and those are traditionally understood as jurisdictional for it, if you're on it. And I think to the extent that there has been argument here that this restraint has some much broader interpretation that really allows habeas to simply serve as an action to review convictions, not only do I not know of any law supporting that proposition, but I think when you read the rest of the statute, when you see a writ that is designed, I mean, the granting of the writ is the remedy, which is you are hereby commanded to have the body of the plaintiff, and it has to be addressed to a defendant.
I have a quick question here. In reading the ruling of the court, it seemed like Mr. Bergmann made some motions, and then the court took it on its own to rule on the merits without a hearing.
I'm sorry, the district court?
Yeah. Did the district court ever even have a hearing on the matter? Did they hear any of these arguments?
No.
Or they just went off and ruled on it without scheduling a hearing the way I don't have the whole record, but.
No, Your Honor, that is my understanding as well. The district court on its own motion found, for the same reasons that I'm suggesting here in the Court of Appeals, that it had no authority to grant a state habeas writ against federal custodians and thus issued a summary dismissal, as I believe is permitted under the statute.
It was done without hearing and without input from either counsel.
Yes, that's true.
You know, Ms. Link, I think the state in general would have an interest in making sure that the convictions that, or the deferred judgments, a conviction and a deferred judgment would be entered against citizens of the state would be done in a constitutional way. Should we wait and see if someone objects to the writ of habeas corpus other than this state?
I'm sorry, I'm not sure I quite
Well,
understand.
why is it that the state wants to, your objection is that the remedy or the procedure doesn't fit the remedy, basically, right?
Essentially, a state habeas is not a grant of jurisdiction to courts to construct whatever equitable remedy fits a particular case. And my understanding, I think actually from one of the cases that dealt with the earlier petition for quorum nobis, made clear that in Iowa, we do not look for remedies beyond the statute, where the statute specifically provides for habeas and post-conviction, which I think we also understand the legislature intending to be the primary vehicle for doing that. There are not other remedies sort of outside the statute.
But wouldn't the state have an equal interest in making sure that remedies are available for people that have complaints that need to be brought before the courts?
Your Honors, I think the state certainly would have an interest in remedies for injuries imposed by Iowa law, but Iowa is not restraining him. We are not imposing consequences on him. The legislature made that clear, I think, in the deferred judgment statute. And I don't think that it is necessarily the prerogative or at least particular interest of states to usually try to constantly revise and draft and move around their laws to overcome or circumvent federal statutes. And I think it's also notable, you know, with immigration, as we've discussed in, for example, sex offender registration cases and other collateral consequences issues, they are civil actions and they can change the law at any time and apply them retroactively. So if Congress decided tomorrow to decide we don't care about convictions at all, we are going to say every time we get wind that an arrest warrant was served, probable cause.
I understand that, but assuming that there is an error in the criminal proceeding, there just aren't any circumstances where the state says, well, we don't have a remedy for that error.
I would disagree a little bit with that on 2 points. Number one, I
Well, in
think,
your brief, you even said that there may not even be a federal remedy. Is this a man without a remedy?
no, and I think I've specifically said I do believe he has a federal remedy, and in fact, I think he has several federal remedies. I also disagree that he never at any time had a remedy. The post-conviction statute is a great thing. If he finds out, let's say, same facts of this case, but not a deferred judgment, he has an actual conviction under Iowa law, but he doesn't find out about his immigration consequences until 3 years and 1 day, so after the statute of limitations is run, we don't say we now need an equitable remedy to allow you to go back and challenge that just because you went where. As he said, he affirmatively waived potential avenues to challenge concerns that he had with the plea, and he did so to gain the privilege under Iowa law of not having a conviction, and thus not consequences, in this state. That is the state's prerogative, and I think that the legislature has fully fulfilled that, and if it's concerned, then it is the policy choice of the legislature to make that determination. Thank you, Your Honors.
Thank you as well, counsel. Rebuttal argument?
Thank you, Your Honor.
Mr. Bergmann.
Could I ask you to respond to Ms. Link's last point? As I understand her argument, he had an opportunity to challenge the deferred judgment by filing a habeas, quite arguably, until he discharged probation. So there was at least a period of a number of months that he could have challenged the deferred judgment. Now, so how is that any different from the 3-year statute of limitations on PCR? We don't let people, if they're 4 years, 5 years, 6 years out, go back and challenge their convictions. Those people are also without a remedy. Why isn't the state able to limit remedies? What's wrong with that?
Well, the statute doesn't say custody, it says restraint. That's number one, it can be decided on the statute. Secondly, the theme,
Doesn't it have to be decided on the statute in this case?
I would recommend that.
Are you arguing anything else?
Well, the habeas flows from the Constitution, but it specifically states that it's done legally, so I think that it goes back to the statute that way too. But the state's whole argument, it flows from the idea that he could have done all these arcane legal things that I had never heard of until I started practicing law. And the argument is ineffective assistance of counsel. I take your point that there is a prescribed statute of limitations in the post-conviction relief statute. And we haven't said out loud yet that it's tainted throughout this, and I can't say that a ruling of you all is tainted all, but he can't file a PCR. Under Dallenbach, he can't file a PCR. And it's said in the petition, it's through our briefs, it's in the ruling of the Court of Appeals. He can't do a PCR, so he only has habeas. The only reason that you all would construe that he would have had to do it while he was on probation is if you're going to conflate custody and restraint.
I think it's as Justice Wiggins with his line of questions suggested, and I think they're good questions, quite arguably he's in restraint of liberty and he has a habeas remedy during the probation period. He does lose that once it's discharged, arguably.
If we're going to go into the academic realm of implying a custody term that's not in the statute.
He's in restraint of the state of Iowa. After that, he's not in the restraint of state of Iowa anymore, and I think that may or may not make a difference.
The conviction is what is doing. The conviction's the restraint. The conviction is the restraint. And
Oh, no, the restraint is what is a collateral consequence, arguably, it seems to me. The fact he's got, it's the collateral consequence that you say your client should have been advised of. Isn't that the basis of the restraint?
that too.
But habeas, I mean, one of the things bothering me, habeas corpus, I have the body. And you heard some of the, parts of the statute. It talks about, traditionally, present the body. And if you look in all the texts and so forth, they refer to habeas as the remedy of habeas corpus. Does it really fit your claim of restraint, when, I mean, I think you agree, or maybe you don't, but we're not gonna order the federal government to present the body. They're not even a party of the case.
If you look at the statute, there's not even a causal connection part in that statute. It merely is a list of things that you need to list factually. There's no causal connection language in the statute.
When you talk about Ralph, they did a habeas corpus, the judge ordered the sheriff to bring Ralph, not the bounty hunters to bring Ralph. And it's a different situation. It's apples and oranges, because you haven't asked us to have I don't know if it's Polk County, wherever it is, to have that sheriff go out and bring the body to the court so it doesn't get sent to Mexico. I mean, that's not what you're asking for, I don't think.
No, and I understand and appreciate the inquiry about what we classically think is a habeas case, but that's not what the statute says. And they could have said that, but the Iowa legislature never has since the very beginning. And I urge you that if you take counsel's suggestion to go with federal cases, look at that Carafas case where they talk about that it shouldn't be construed so narrowly, and look at the Tennessee Supreme Court in the May case, and look at the Georgia Supreme Court in Paris v. State, 232 Georgia, or rather 208 Southeast 2nd, 493, where they say that this should not be construed so narrowly when there's such severe collateral consequences. And both those cases talk about state habeas cases where there's collateral consequences. Is it such a case that the Iowa judiciary is so bureaucratic that every I has to be dotted and every T crossed for someone to seek relief where there is no other relief? He can't go to federal court and get this done. He cannot do it anywhere else. He can't do it in a PCR under DONBA. The option for you all is either leave him in the cold, or there is relief for people that get deferred judgments that suffer ineffective assistance of counsel. And I encourage you to give him relief. Thank you.
Thank you as well, Mr. Bergmann. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.